Good morning, everyone. Welcome to our third webinar in the Education Law series. Today's topic is Understanding Special Ed Law, Exploring What's Old and What's New with Professor Emerita Julie Mead. This is the Place Exchange, a forum for educators, families, and communities. And the Education Law webinar series is hosted by the UW School of Education's Department of Educational Leadership and Policy Analysis and Place, the Professional Learning and Community Education Office. Thank you to the School of Education Dean's Office and the Mary T. Kellner Teacher Education Center for their sponsorship, and for all of you for joining us on this Saturday morning. You can find us on YouTube and look for the recording of this session as well as the previous two sessions at Place UW-Madison 3991. And also you can find the links to the YouTube on our webpage. A quick shout out to our upcoming session, which will be on Wednesday, April 29th from 4 p.m. to 5 p.m. The topic is Beyond the Off Switch, Evidence-Based Strategies for Healthy Digital Habits in Children. And that will be presented by Larissa Niech, a professor in the Department of Counseling Psychology. We're really excited about that upcoming session and also excited to test out a new time. We're gathering feedback about whether or not this Saturday time slot works well for folks. So we'll be testing out a Wednesday early evening session. You can register at the link or QR code there. We'll have this slide up again later in the session. And speaking of feedback, this is a new series offered by Place, and we're curious to know what topics, what experts do you want to hear from, what time works well for you. So please, we welcome and invite and are eager for your feedback. We'll paste this link in the chat a few times throughout the session. You can also scan the QR code to give us your feedback. And some logistics for today. So all of you were muted upon entry. If you have questions, please put them in the chat directly to me or to Sandra. There will be a Q&A at the end of this session with Julie. It says Suzanne, but it will be with Julie. The lecture will be about 55 minutes and will be recorded and shared. The Q&A portion will not be recorded. So please keep your questions broad and anonymous by not mentioning names, places of employment, and specific questions that only pertain to you. Closed captioning and AI transcripts have both been enabled for accessibility, and the PDF of the slides will be shared at the end of the session. And with that, I'll pass it over to Suzanne.
Good morning, everyone, and thank you for coming. This is our third session on education law. We had a three-session series. We began with new developments in education law. Our second was on students' First Amendment rights. And today we have understanding special education law, exploring what's old and what's new. So thank you so much, Stephanie and Sandra, and to your whole staff at Place for helping facilitate these three education law sessions. We are trying to focus on educators in general, with paying specific attention to teachers and other educators in schools. I am so pleased that we have Julie Mead. Dr. Julie Mead is our presenter today. I'm looking at the list of participants, and I know many of you maybe had Dr. Julie Mead as a professor or you have worked with her in other ways, but she is an expert, an absolute expert in special education and law. She has written several publications on special education legal topics and made countless presentations nationally across the state, has supervised so many different teachers or graduate students in this area. and has just had a tremendous impact on special education law. So thank you very much, Julie, for being here today. I'm going to turn it over to you.
Well, thank you, Suzanne. With that, I feel like I need to lower your expectations a little bit, but let's get started because, as many of you know, talking about this for me is something that I could do for a very long time. So to make sure that I get done in an appropriate amount of time, let's get going. So first, I feel as though I need to be real honest that we're mostly going to be talking about what's old, not what's new, because the laws that we're talking about are actually pretty settled right now. The oldest is more than 50 years old, and the newest is more than 35 years old. So we have this trio of laws that we're going to talk about. And as I prepared for today, these were the questions that kind of animated what I put together for you. Um, I know that we have folks from a variety of perspectives, teachers, other school professionals, as well as parents. And so I've got a lot in here, some of which you may be familiar with, some of which may be new, but I hope I can give you a kind of a new way to think about it. As it says there, what I really want to focus on is not only what the laws are, but how they work together, what practices and procedures do they require and why, and the roles and responsibilities of parents, as well as how it all relates to equity. And that last question and the why question is really the most important. In my view, too often we talk about special education as a series of forms and checkboxes without really understanding why they exist and what they're intended to do. So that really is going to be my focus. So the three federal laws that we're going to be focused on today are the Section 504, the Rehabilitation Act of 1973, the Individuals with Disabilities Education Act, that was originally passed in 1975, renamed in 1990. At the same time, Congress passed the Americans with Disabilities Act. Two titles are really around schools. Title II is about public schools. I should say Title III, sorry about that, Title III for private schools. So starting with Section 504, well, first it's important to understand that it's civil rights legislation. It's the first of the trio to be enacted by Congress. It prohibits discrimination on the basis of disability. And one thing that I'll emphasize is that understanding how these laws both are similar and how they differ really is focused on the purpose. If you can remember the purpose, you can kind of untangle them as you go forward. So here, the purpose is to prohibit discrimination on the basis of disability by any entity that receives federal financial assistance. If the goal is the prohibition of discrimination, then it doesn't make any sense to have an age limit on it, right? So this applies from birth to death. And so in schools, it applies to not only the students in the school, but the employees of the school, the parents of the school, and anybody who comes to the school to take part in a program that the school offers. So it covers everybody. This does not have any money associated with it, but there is, and the reason I have a stick act there in the middle is that it's a penalty act. So you do it right or you can be punished. That's basically what's happening here. Eligibility to be eligible for protection under the Act has three categories. And the first one might make perfect sense to you, a mental or physical impairment that substantially limits one or more major life activities. Hold on that. I'll explain that a little more in a minute. And then the second is has a history of such an impairment, or the third is regarded as having such an impairment. Those second two categories may have you scratching your head a little bit because in both of those cases, the person does not have an active impairment that is limiting them. But again, because the goal is to prohibit discrimination, if someone is being treated differentially because somebody, the discriminator, thinks someone has a disability when they really do not, that's still discrimination on the basis of disability and something that this act exists to prohibit. So in terms of those two categories, what might that be? Well, a history of such an impairment, someone, for example, who had cancer and no longer does, but someone is treating them differently because of their knowledge of that history. The third one, probably one of the most common, is someone who's HIV positive, doesn't actively have any kind of impairment, but has an antigen in their blood, but people treat them differently because of their knowledge of that status. That would be being regarded as having a disability. So eligibility is broad because the purpose is broad, the prohibition of discrimination. So let's talk about those major life activities. Well, as you can see from the definition that's taken directly from the statute there, it covers just about everything goes along with living. And notice that they say but are not limited to, include, but are not limited to. And so you have everything that you can imagine there: caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. So it's supposed to encompass everything. Again, broad definition because we want broad coverage to make sure that we tackle or eliminate all forms of discrimination on the basis of disability. So what happens if you are covered? Well, it means that you have reasonable accommodations. Why? To remove the effects of that discrimination, to ensure non-discriminatory treatment. Now, obviously, if you're in the last two categories, the only thing that needs to happen is that the discriminator needs to get some sense and not do that anymore. But if someone has a mental or physical impairment that substantially limits one or more major life activities, they may do reasonable accommodations or modifications to allow someone to navigate a space, receive information, or express ideas. Those modifications or accommodations are individually determined. In other words, you have to, and this is what really makes this law so challenging, you have to look at the individual to figure out what accommodation is due. They have to be reasonable. They do not have to be perfect. They don't even have to be the accommodation that somebody prefers. They only need to be reasonable in order to remove any kind of discriminatory effect. What accommodations are not are measures to take assignments or activities more enjoyable, although they may. Measures to make the school experience failure-free? Nope. Measures taken either to protect kids or protect teachers? Nope. Although again, they may have that effect, but that's not the purpose. The purpose, again, back to the law, is the elimination of discrimination. The Americans with Disabilities Act extends the protections of 504. Remember, 504 is only applicable to entities that receive federal financial assistance. ADA, which happened, a little more than 15 years later, extends those protections beyond that receipt of federal funding into the private sector. And you can see that you've got, excuse me, a series of titles. In schools, we typically talk about Section 504 when we're talking about kids, and ADA when we're talking about grown-ups, although both acts cover both entities. And again, because the purpose is the prohibition of discrimination, it's birth to death, no age limitation. Same eligibility criteria, same three categories: mental or physical impairment that substantially limits one or more major life activities, a history of the same, or is regarded as having the same. That brings us to the Individuals with Disabilities Education Act, which is in many ways, if you work in schools, the big dog, right? This is the one that people encounter the most frequently because, frankly, it is the most detailed and most procedurally dense. I may shock you by saying that it is not technically civil rights legislation like the other two. This has a different purpose. It's child welfare legislation, and its purpose is to provide money, to provide funds to states to assist them in the delivery of special education and related services. So because that purpose is different, to provide special education and related services, now an age range makes sense. Now we're talking 3 to 21. And this one is what I call a carrot act. So in other words, it dangles this money, this pot of money, says, here, states, if you promise to do everything that's in this law, you can have some money. Technically, that means it's not a mandate, though all 50 states have accepted the money. So, as in practical terms, it is. It's very, as I said, procedurally dense. It has both procedural and substantive regulations. And that's important because this grew out of litigation around the 14th Amendment's due process clause. And if you understand 14th Amendment due process, you might know that we have procedural due process. We go through procedures to ensure that we get substantive due process. Substantive due process is the notion that we got it right. So we have procedural and substantive regulations. Eligibility is different, again, because the purpose is different. So eligibility now is a disability that adversely affects educational performance such that special education is needed. And I think you can see the connection there, right? If the law exists to fund special education, only those students who need special education are covered by this law. So how do we put those together? Well, imagine, if you will, that this blank screen is all people in the United States. A subset of all people are those people with disabilities who are protected by Section 504 and ADA. Another subset of all people are kids who are school-aged. And of course, there's an intersection between those two groups of people, the overlap that you see between my two circles. IDEA children are a subset of that intersection. So some kids who have disabilities also meet the eligibility requirements for IDEA, but not all kids with disabilities meet those more stringent eligibility requirements. So a way to think about this, you may have remembered when you were a kid and you learned about squares and rectangles, right? All squares are rectangles, but not all rectangles are squares. Well, the same thing. Here, all children who are eligible under IDA are triply covered. They're eligible under all three acts. But not all kids who are eligible under Section 504 and ADA are also eligible under IDEA. Again, because IDEA exists for a different purpose. And so you have to, if you will, demonstrate that you need special education in order to be eligible under IDEA. IDEA's theory of action is both challenging and simple all at the same time. And it stems from the fact that at the time that this was initially passed in 1975, Congress heard lots of testimony and had lots of data that showed that kids with disabilities were often excluded entirely from school. And even when they were in schools, they were often not provided with an appropriate education. So the whole theory of action of this law is that if we do the procedures right, equity will follow. If we do the procedures right, by considering the individual child and the unique needs of that child, and we develop a program to address those unique needs, then children will no longer be excluded or inappropriately served. Now, depending on who you talk to or what you read, you'd have a different set of core concepts. This is the Julie Mead version of the core concepts of IDEA. And I always start with that middle shape that, you have to learn to speak acronym when you're in special education. And it's FAPE with an IEP in the LRE. And I think Dixie Snow Hefner actually first coined that, and I appreciate that. So what's that mean? A free, appropriate public education as defined by an individualized education program and delivered in the least restrictive environment. That's the child's entitlement. That's important because that puts the child and the individual child at the center of everything that we're considering under IDEA. It's the child's entitlement, not the parent's entitlement, not the teacher's entitlement, not the school's entitlement. It's the child's entitlement that this law protects. That entitlement has to be considered in a context that has three characteristics. First, individualized determinations. That I in IDEA looms large. It has to involve parents, and it has to come as a result of group decision making. All because prior to this law, often parents weren't involved and there wasn't group decision making. So all of those things are an important part of the context. And then all of that is bounded by a set of very clear and robust procedural protections, which I talk about being two guardians of FAPE, both the parents and the school, and I'll talk a little bit more about that later. So let's start with FAPE. Well, this is the statutory definition, and each word has some meaning there. So free means exactly what it says, at public expense. It has to meet the standards of the state educational agency. That's part of appropriateness. The other part of appropriateness, of course, is it has to do with the child and conformity with that individualized education program. The United States Supreme Court has considered this idea of FAPE twice, the first time in 1982 in a case called Board of Education versus Rowley. And in that, we learned several things. First, they determined that FAPE did not require the school district to maximize a child's potential, but rather that FAPE is what they called a basic floor of opportunity. So I want you to think about that, a basic floor of opportunity. We can build from a floor, but we can't go below it. So by definition, FAPE is the least we can do for a child. It's the floor of opportunity. Then the court said there's two things that we have to consider. And again, back to 14th Amendment, both procedural and substantive. So there's that link once again. So has the district complied with the procedural requirements of the act? And is the IEP reasonably calculated to confer benefit? In application of this test, numerous courts have pointed out that the court may forgive minor noncompliance with procedural aspects, but they will never forgive an IEP that is not reasonably calculated to confer benefit. So of those two, procedural versus substantive is always the more important. And of course, it brings up that word benefit. And what in the world does that mean? Reasonably, somebody might look at that and say, well, maybe that question is, would the child benefit from the program or service? It's a reasonable question, but it's not the question that the law requires. The law requires, again, going back to the purpose, that we look at the benefit. Does the child need that benefit to get that floor, right? Do they need the benefit in order to benefit from, they need that program or service in order to benefit from the educational experience? Then in 2017, we had the second case that the Supreme Court examined this notion of FAPE. And part of the reason that they did was because the 10th Circuit, the court below, had said that, oh, you just needed to have some education benefit, even if it was very minimal, de minimis, very minimal. And the Supreme Court unanimously said, nope, that's not what this means. But they resisted in a unitary definition that FAPE can have these check marks, and we always know. Nope. It depends on the unique circumstances for the child that was created, and it has to be a program reasonably calculated to make progress appropriate in light of the child's circumstances. So all that focus again remains on the individual child, what the child can do, and what the child needs in order to progress in a manner as much as possible consistent with their peers. So that brings us to that thing called an IEP. And what is an IEP designed to do? Well, that's the document we use to define that floor of opportunity. That's where we lay all of that out. So if you connect all those dots, then you understand that in essence, an IEP is an individualized equity plan. It says, this is what we're going to do to create an equitable educational experience for this child. Understanding the IEP means you have to really pay attention to three aspects. You have to pay attention to the team, you have to pay attention to the meeting and what happens there, and you have to pay attention to the document. So the team, here again is the statutory definition of the team, and notice who's listed first. The parents are a full and complete member of the team. Then we've got some kind of crazy statute speak, not less than one regular education teacher, not less than one special education teacher. You think, well, why are they doing that? Well, they want to make sure, excuse me, that you have somebody who is a regular education teacher who can understand and communicate what the standard curriculum is and how this child functions in that standard curriculum. You want a special education teacher, someone who is trained to understand the educational effects of a particular disability or a particular suspected disability, and who can explain those and how those interact with the general curriculum. You have to have a representative of the local education agency who has those characteristics. And again, notice that knowledge about the general curriculum, because that individualized plan is supposed to help the child advance in the general curriculum. The individual who can interpret in the evaluation results, and then at the discretion of the parent or the school, other people who may have knowledge about the child and how the child functions. And then lastly, but not in a limited way, the child. And whenever appropriate, and part of this again is that we're trying to train the child again to become their own advocate as they grow. And so when it's appropriate to include the child should be a member of that team as well. The team at that meeting has several responsibilities. They have to look at the evaluation. They have to make a determination of eligibility. They have to develop an IEP, and based on that IEP, determine the placement of the child. There are some timelines associated with that. This is the graphic that DPI uses to express that timeline. Frustratingly, IDEA uses three kinds of days: business days, calendar days, and school days. Would be helpful if they picked one, but they didn't. So you have to pay attention to what kind of day we're talking about, and this graphic does a good job of laying that out for you. But the idea is that once we are going to evaluate a child to determine whether or not they have a disability that meets the definition under IDEA, we have to do so in a timely manner. And once we have determined eligibility, we have to, if the child in fact is eligible, we have to create that program and place that child in the program as quickly as possible. So what has to be on that IEP? Well, as you can see there, the law itself dictates all of the elements of the IEP. And again, you go back to the purpose. Why are we doing this? To have an equitable educational experience for the child. All of these make sense, right? So we need to understand how the child currently functions. What are all of the things that they do, all their abilities, so that we can build on what they know to tackle what they don't. So when we're focused both on a broad academic achievement and functional performance, which tells you that this law defines education very broadly. It's not just reading and writing and arithmetic. We have to have measurable annual goals so we can see how the child is progressing. Special education and related services have to be spelled out, as do supplemental aids and supplementary aids and services. And may I point out how you spell aid there? AIDS, meaning help, not AIDE, meaning a person. Now, the aid help may come in the form of a person, but the law is focused on thinking about how are the ways that we can help this child, supplementary aids and services, program modifications and supports, the extent to which the child will not participate in the regular class, which of course we'll talk about later, creates a presumption that they will, how they're going to participate in assessments and what accommodations are needed or alternatives are needed, projected date, frequency, duration, so forth. Transition, this means transition to post-school life. Transfer of rights to the child as they reach the age of majority, and then how progress will be measured and reported. These are the definitions of both special education and related services. Special education comes first. Related services is related to the special education, so there's a link between those two. And notice again, there's a focus on the unique needs of the child. The related services is a bit of a laundry list because you don't know what the child might need in order to help them benefit from the special education that they're receiving. Then the law requires that we consider a series of special factors. And as you read through those special factors, each one of those came about because at some point or other in the delivery of this law from its inception, people weren't giving adequate consideration to these special things in these special circumstances. So you have to examine behavior. And I will point out this first one. This does not apply just to someone with a behavioral disability. It applies to any child with a disability for whom behavior is an impediment. It does not mean that the child has to meet the definition of a behavioral disability. Limited English proficiency, visual impairment, hearing impairment, and a need. Oh, one other thing about behavior, notice that the focus then is not on a series of punishments. That's not the idea. The idea, again, how do we teach positive behavioral intervention supports and other strategies to help the child to not have behavior that impedes learning going forward? So the overriding principles for IEP construction are these three. First, it has to be based on a child's unique needs. It has to be designed to allow the child to both access and progress in the general curriculum, and it has to be aligned to the same state content standards that every other child's education is aligned to. So now we're on to the next core concept, which is the least restrictive environment. This one's interesting in that it doesn't have a statutory definition, although it's been in the law since its inception, just in different spots. It is now a heading in the statute, and it does remain individually defined. So it's not appropriate to say the least restrictive environment is the traditional classroom. No, it's not. It may be, and probably is for the vast, vast majority of children, but this requires that we consider the environment that least restricts a child's learning. That's why the language is listed that way. Although you can see again on the statutory language, to the maximum extent appropriate, again, notice the word appropriate, that harkens back to the idea of FAPE. So not to the maximum extent possible, but to the maximum extent appropriate, children with disabilities will be educated with children who are not or do not have disabilities. And that anytime we do something different, we have a child-centered rationale based on the nature and severity of the child's disability. So a child-centered rationale that says, I can't achieve that equitable experience in the regular classroom, so I need to do something different because of this particular child, based again on a child-centered rationale, not based on whether or not the school has a program, but based on whether or not the child needs it because of the nature and severity of the child's disability. The regulations then require that the public agency, and here you can read school district or independent charter school, state, has to have a continuum of alternative placements. Again, why? Because disability expresses itself in a wide variety of ways. And so there has to be a wide variety of environments that we might use to meet the needs of the child, even though that really heavy, strong presumption exists that we're going to have kids in the regular classroom whenever appropriate to do so. And you can see the list there: instruction in regular classes, special schools, home instruction, instruction in hospitals and other institutions. Again, depending on the child and the unique needs of the child. When it says it has to make those placements available, not to be crass, but it really means they have to pay for it. So that doesn't mean that each school has to have everything or that each school district has to have all of those things, but they make them available by providing the financial assistance to place a child in one of those settings if necessary. Placement gets a little dicey because it's technically not synonymous with place, although place has a big thing to do with it. But it really talks about that menu of services and supports that are going to be provided, as well as the location of those services. It has to be individually determined. It's based on the IEP. So we write the IEP, then we determine placement. We don't put the child in a setting and then write the IEP. That's backwards. IEP first, placement second, has to be determined at least annually and has to reflect the least restrictive environment. So some of the changes that have been made over time have helped us to distinguish between this notion of an all or nothing removal, is what it's often termed, And that's because Congress heard a lot of testimony that if a child was placed in a separate setting for all or part of their school day, they didn't get the same stuff. They didn't get the same general curriculum that everybody else did. They got something different. And so to cure that problem, when Congress amended the law in 2000, well, first in 97 and then in 2004, they made really clear, especially in 2004, that whenever you're in a separate environment for a portion or all of the school day, there's still the notion that you have the general curriculum, even if you're in a separate class. So when we think about regular class placement, it's not a sink or swim thing. It's a regular class placement with all of those supports, right? Curricular adaptation, support, supplementary aids and services, all of that there to help make the child successful. And even if we get through my flow chart here and you say, no, there has to be some adaptations made, it's still aligned to state standards, even though it may not be on the same level as some same aged peers. If a placement doesn't seem to be working, the law then contemplates that there are two possible reasons. Either the child is inappropriately supported or inadequately supported or inappropriately placed. And the law requires us to consider the first. Are there other additional supports that we can add to make this child successful in the general classroom, if you will, or in their current placement before we consider whether or not we need to think of a new placement altogether? So a little bit more about IDEAs. A little scared to put this in because discipline can be a really detailed and difficult, complex to explain, but I'm going to give it a shot and do it real quickly. So first, I'm going to start with regular discipline. Regular discipline all has to do, so this is kids with disabilities, kids without disabilities. We know from Supreme Court decisions that all of those things have to do with this notion again of due process under the 14th Amendment, that we're not going to take something away like education, which is a big deal. We're not going to take away educational opportunity unless we're very, very careful. So the primary principles that apply to all school discipline are these three. First, that all the rules must be reasonable and serve an educative purpose. Why an educative purpose? Because we're a school. It's that simple. We're a school. And so we provide consequence to teach, not consequence for its own sake. Secondly, that consequences have to be proportionate to the infraction. You don't expel somebody for chewing gum, for example. So you have to, if you're going to take away more, the last one, you have to examine more carefully. That means that the process due fits the contemplated deprivation. The more I'm going to take away through suspension or expulsion, the more careful I want to be that we've got it right. That applies to everybody. Child with a disability, child without a disability. Child with a disability, all it says is that that factor, the child has a disability, raises another set of questions that we have to use in order to be fair and follow the first three. And those new questions are, is a misbehavior a manifestation of the disability? Because if somebody truly doesn't understand that what they did was wrong or truly doesn't understand or cannot control what they did, it's not fair to discipline them in the same way as someone who does understand and can control. The second one is because a change of placement under IDA, whether for discipline or anything else, always adds extra procedures and always includes the parents. So if the possible consequence is a change of placement, we're adding more procedures. Again, because of that due process deprivation idea. And then finally, the last one I say is the equivalent of thou shalt not set children up. So if the child is not receiving that to which they are entitled, a free, appropriate public education, and then something happens, and you can relate those two, the denial of FAPE had some implication or had some causal connection to the misbehavior, then it's not fair that the child is then penalized for something that the school district should have been paying attention to in the first place. I lovingly call this my spaghetti chart, and I'm not going to walk through my spaghetti chart. All I really want to point out is that it's got two endpoints. use the regular discipline procedures or use IEP procedures. There's no bubble that says do nothing, kid gets no consequence. Nope. This law says you can have a consequence for every misbehavior. It's just which series of procedures are you going to use to effect that consequence. In other words, if we ask those 3 questions about equity for kids with disabilities and we are satisfied with all 3, then it is appropriate and fair to use the same disciplinary procedures that you would use for any child who has misbehaved. So when you think about that, then it's important to kind of think about it in these 3 buckets, if you will. First, we need to look at IEP programming. We need to look at whether or not the misbehavior suggests that we don't understand enough about how this child functions, that we need some more evaluation. We also have to make sure, were we, in fact, as school personnel, providing FAPE? Was it being provided at the time the misbehavior occurred? And we have to look at that both in terms of what programming and in terms of placement. Manifestation determination is what we call that examination of the relationship between the misbehavior and the disability. It's only required when a removal of greater than 10 days is contemplated. It's a good idea to ask the question every time, but the law only requires it when you're doing a removal. In other words, when the deprivation gets bigger, we're going to be more careful. And then there's a second set of considerations, and that's when dangerousness is at issue. And so if there's a gun, a weapon, drugs, or serious bodily injury, the school has unilateral authority, whether the parents agree with us or not, to remove the child for up to 45 school days. If the child, does the child pose a danger to itself or others, that is, again, has another procedures that allow the school to take action to protect the child or to protect others if dangerousness is an issue. So knowing kind of how to look at IEP procedures to get where we need to be is important. But again, I want to emphasize, you're never in a situation where you are forbidden to employ a consequence. Sometimes it just means that expulsion is not an equitable response to whatever happened if that there is a relationship between the misbehavior and the disability. So when do you have to do that manifestation determination? Again, when a change of placement is contemplated, you have to do a manifestation determination. You still may end up doing a change of placement. I want to mention that. You're just going to do it through an IEP procedure, not through the general discipline procedures. When do you have to do it? Removal of greater than 10 consecutive days or 10 cumulative days, maybe, which is frustrating. But let me point something out. So when, because of the Constitution, do we want to make sure that we're careful? 10 days. The Supreme Court said that in an old case called Goss. When do we want to make sure that it's okay under IDEA? 10 days. Look at that. Under a case called Honig versus Doe. In other words, whether we're talking about constitutional protection for all kids or statutory protection under IDEA, the answer is the same. 10 days is that point at which we want to make sure that we're being careful and that the process that we're using is proportionate to the deprivation that we're contemplating, that we are being careful enough when we're getting ready to expel a child. That cumulative one's like, doggone it, could they have just answered it one way or the other? But they didn't. They had a lovely giant maybe. And the maybe, it considers these factors: the length of each removal, the total time removed, the proximity, similarity of behaviors, and the effect on fate. Again, it's probably prudent to be counting days and to be asking yourself these questions before you hit 10 days, but that's how we determine whether cumulative days of removal, in fact, create a change of placement that require that manifestation determination. You don't have to wait for 10 days, though, people. You can consider all of these things prior to. If you do determine that greater than 10 cumulative days, but no change of placement, in other words, it's right and proper and equitable to use the same disciplinary procedures that you apply to everybody else, then you still have to provide some services for the child to progress in the general curriculum and to move forward on IEP goals. So again, a little more about the manifestation. It's a special procedure. It pulls back the IEP team, but you don't have to have the full one. The law says you have to have an LEA representative, the parent, and relevant members of the IEP team. They don't define what that is, but relevant in terms of the child and the misbehavior. My thanks to Maria Lewis for making this lovely graphic to help us consider that. The law requires those 2 questions that she's got in the little pink box there. What are those 2 questions? And the bottom are all of the kinds of things, all of the sources of information that are supposed to be considered to answer the 2 questions. So the first one is that there's some direct, okay, I'm hearing something. That must be from you, Sandra.
It is. It's
Okay.
lovely, isn't it?
Yes, that's very lovely. But now I know what's going on. All right, I'll scoot. So we've got the first one that's looking at that real connection, and it has to not be an attenuated connection, step, 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 but a more direct connection. And then the second is that one about the district's failure to properly implement an IEP. Again, just reinforcing, we're using one of 2 sets of procedures. We are never in a bubble that says sit on your hands, do nothing when the child misbehaves. There is special school authority, as I said, when there is an issue of dangerousness. Serious bodily injury is defined. So is bodily injury. I'll be honest, I look at those 2 and scratch my head and say, how do I determine where one is and one isn't? But it's clear that one is more dire than the other. And so serious bodily injury is the one that, so not just any bump or bruise, but something really serious is what they're talking about in that provision of the law. And then there's a provision of the law that just allows, if there are concerns that the child is either a danger to themselves or others, that they can be placed in an interim alternative educational setting. They can do this through a hearing officer, or they can go directly to a judge and ask for what's commonly called a Honig injunction in order to have that placement made. So what is that interim setting? Like everything else in the law, it's determined by the IEP team, which means it's individually determined. It has to enable the child to participate in the general curriculum, the stuff, not the place, but the stuff, and to meet the goals set out in the IEP. And this one's a shocker. Pretty sensible, if you ask me. It must include services to address the behavior so that it does not recur. Again, we have to have reasonable rules that serve an educative function. There are also these things called a functional behavior assessment and a behavior intervention plan. Their names are kind of, although there's no technical, statutory, or regulatory definition, the names are pretty self-evident. The one is we figure out what antecedents to behavior are so we can program to help that behavior be addressed. And the plan has to be focused on positive behavioral intervention strategies and supports. Again, all determined by an IEP team. Then we switch to procedural protections. As I mentioned, 2 guardians of FAPE, 2 entities to ensure that the child's entitlement is being met. Parents, making sure that school districts are doing what they're supposed to, and the school district, because the school district has what the law, what we term in the law as an affirmative obligation. So unlike adults who have to disclose a disability, in K-12 land, the school officials have to discover or investigate a potential disability and then have to identify, locate, and serve as appropriate. We have a whole series of categories of rights for parents to serve as the guardians. They have 4 groups, 4 buckets: notice provisions, consent provisions, participation provisions, and challenge provisions. And given my time, and I want to let you ask questions, I'll just briefly go over them. So notice provisions are basically the right to have notice of your rights under the law and notice whenever the child either initiates an evaluation or makes or refuses to make a change of placement. Consent to grant or deny permission to evaluate and grant or deny permission to place in special education. Participation provisions, so being a member of the team, access to records, participating in all decisions, have information explained to them, have copies of documents about their child. So all of those kinds of things, including the last bullet, if they disagree with the school's evaluation, they can request what's called an independent evaluation at public expense. And then complaint provisions, which allow mediation and other forms of dispute resolution in order to resolve a dispute between the parents and school officials. So here are the 5 procedures that are laid out in the law. Again, really procedurally dense law. A resolution session, so, can we solve our problem without going to a formal process? Mediation has to be offered, although the parents and the school district can decide mediation is not going to work. Due process complaint, which is a formalized hearing with an impartial hearing officer and with a binding decision. There's another complaint procedure that is a parent or others can use that argues that the school district is out of compliance with the law, and then a judicial appeal if there's an adverse decision for either party after a due process complaint. So really quickly on what's new, as I mentioned, we're really focused on what is, and because Congress has not amended these laws, IDEA was last amended in 2004, and the other 2 were last amended in 2008. But what's new is really what's happening with this administration. About a year ago, President Trump signed an executive order to dissolve the Department of Education. Now, the Department of Education exists because of congressional action, so it would suggest that he can't do that without congressional authority. But be that as it may, we do have this executive order. For special education, it raises concerns about both the Office for Civil Rights and the Office for Special Education Programs, whether or not sufficient personnel and sufficient individuals with the expertise necessary will be there to implement these very important laws. There is rumors, although to my knowledge, so far, nothing has actually happened, where the OCR would be transferred to the Department of Justice and the Office for Special Education Programs would be transferred to either the Department of Labor or the Department of Health and Human Services. So I wish I could provide more insight into that, but we're just waiting to see. And then the last thing I'll mention is that special education funding is a perennial thing. You may have heard that IDEA is not fully funded. When they say that, what they mean is that Congress has always, from the first time the law was enacted, has been authorized to provide states with up to 40% of the costs. But they've never appropriated, in other words, actually written the check at that level. In fact, we're at about 12% right now. Obviously, if the federal government is only providing 12%, that means that the states have to make up the difference depending on how your state is dividing it between the state sources of funds and local sources of funds. Advocacy organizations have long argued that Congress should fully fund at that 40% level the IDEA. And remember, that's the only one of the three laws that has money associated with it. And with that, let's see what questions you might have.
Hi, Julie. Thank you for all the information. It was really informative. One question that came in from KJ Manzek, I hope I pronounced your name right. It has to do with homeschooling. If a student is homeschooled but attends 2 classes per day, and I should say that this is there are multi questions. So if you want me to read the whole thing or if you want me to read parts. So if the student is homeschooled but attends 2 classes per day, does the student remain fully eligible for services under the IDEA, Individuals with Disabilities Education Act? And then what happens to the services written for classes the student will no longer attend? And should the IEP specify that some goals or services are implemented only during school attended periods?
So an IEP isn't a menu. You don't get to pick the part you like and not have the others. IDEA does not apply to somebody who is homeschooled. So there are some provisions that apply to private education when a child is placed by their parents in a private school. But there is no federal requirement that school districts owe homeschooled children similar support. So in other words, we may send supports into a private school to support a child with a disability in a private school, but we would not send a similar support into a homeschool environment. Now, if the child is partially enrolled in the public school, then thinking about the accommodations due if the child is eligible under Section 504 and ADA only, if they're eligible under both or all three, if you will, then you might be thinking about what kinds of accommodations are necessary or what kinds of services are necessary to ensure that that the access to those two classes is provided in a non-discriminatory way and that it's appropriate, the services are appropriate in that setting. But when an IEP is written, that IEP is written for the whole placement, and the parent is either going to grant permission for the whole placement or deny permission for the whole placement. So when a child, again, is only in school for a couple of classes, it's not going to have that child and those parents are not going to have the same kinds of rights as would a child who is there for the entire school day.
Okay, so just to clarify, to make sure we're understanding, it sounds like the child would not have an IEP, but the child could have accommodations or a 504 plan for the one or two classes that they're there. Which would also mean one of the other questions was about writing goals for those specific classes. But it would look different specifically because that child has two placements, so the laws don't
Right,
aren't the same for that child.
right.
Great. Thank you so much. Um, one of the things I've been thinking about actually from my time in K-12, you did a great job of talking about all the things that have to happen on the school's end. But what about the parents who may not agree to the services or they don't? I mean, that's their right, correct?
Right.
Um,
So there is a provision. So again, remember the school district has an affirmative obligation to identify, locate, and serve. So the law does permit that if a child, if the teachers all suspect a child has a disability and the parent refuses consent to evaluate, the school district may, is not required to, but may take the parent to due process to get a hearing officer to override that parental denial, for the hearing officer essentially to grant permission to the school district to evaluate the child. Then if the parent doesn't want the child evaluated, they'd have to withdraw the child from the school if the hearing officer rules that way. Now, obviously, that's a tool that school districts use very, very sparingly, but it is there. If you go through the process and the parent and the school district offers an IEP and a placement and the parents deny consent for placement, for initial placement, I should say, for initial placement, then the school district can't appeal that through a due process hearing. But what that does mean is that the parent can't later come back and say, hey, you denied my child a free appropriate public education because I said no and you didn't do anything. Yep. You said no. And when you said no, that kind of ability to challenge the district to say, you didn't do anything, um, uh, evaporates to some degree. Now, the school district still then would have to think about, okay, what reasonable accommodation short of special education and related services can we provide to help make this experience as equitable as possible? But if the parent denies permission to place, then they lose some of their rights to challenge if later on they decide that they made a mistake. Or if the child gets in trouble discipline-wise too. Yeah.
Great, thank you. Susan has a question. What can a teacher do when the district is not providing the appropriate allocation to meet the child's IEP? For example, if the child's supposed to have one-to-one support all day, but there are times during the day when that's not provided. Therefore, giving that child the support that's needed from the teacher, it's difficult to meet those needs because that child doesn't have the one-to-one support that they're supposed to be
Yeah.
getting.
Well, this is dicey. I understand that because the teacher in that situation is in a political conundrum, right? They need to do what's necessary to advocate for the child. So being a squeaky wheel, but I understand being a squeaky wheel can be a little scary sometimes, but making sure administrators know that. Because if the parents were to ever challenge the sufficiency of the IEP, that teacher now becomes the parent's witness, right? When everybody is deposed about what's going on with this child, the teacher's going to say, well, they were supposed to have a one-on-one aide when they were in my class, but they only did on Monday and Wednesday, and they didn't on Tuesday, Thursday, and Friday. That is going to be a problem. So making sure that administrators understand that the IEP is not being fully implemented is a first step. There is that provision, that state complaint procedure. Technically, those can be filed by anyone, a parent, a community member, an observing professor, and a teacher, right? So a teacher could file a complaint with DPI saying, my district is not in full compliance with IDEA. Again, that would be a really difficult position to be in, but that is available for the teacher who's frustrated that an IEP is not being fully implemented. Obviously, you need to try all of those other machinations, but you do have that tool available.
Thank you. That's helpful. I know the answer that they want, but that's helpful.
There's no easy answer. I'm
There
sorry.
are no easy
There was an
answers.
easy answer, but there's no easy answer.
Right. This is from Kay Find. I'm sorry, I'm probably saying that wrong. But when determining SDI minutes in a high school pullout setting, should IEP teams base the minutes on the students' instructional needs or align them with the length of the available class period? And then how do we avoid documenting like seat time instead of actual SDI?
Okay, well, first of all, let me make sure that you're using the same acronym I am. So how are they defining? Did you say SDI or STI?
SD like dog, I. They did not define it. They just said SDI.
Specially designed instruction is how I would define that. But so especially everything in an IEP is dictated by the needs of the child. So, I mean, obviously, depending on how we organize things, um, the question would be if the child needs support and you're in a structure with 50-minute classes, for example, in a high school, at that point, if you're not providing 50 minutes of support, if the child doesn't need 50 minutes of support, I'm scratching my head a little bit, but if they're not needing 50 minutes of support, can they be, what would they be returning to if they're not getting all of that support? The biggest answer, again, a frustrating one, is that the child's needs dictate what happens, not the administrative structure of the school. The child's needs dictate what happens. Now that obviously there's an intersection between the two, and then you have to kind of think through things, but the child's needs are what dictate what happens in an IEP.
Thank you. This is an interesting question as well. Um, Danny Mall, I think, might be. Um, what are reasonable expectations for the learning growth of students with disabilities? Often their outcomes are compared to those of children without disabilities. Is that fair? And what is an appropriate way to look at the achievement of students with special needs to determine if they are receiving an equitable education?
Okay. So here's where it gets a little bit dicey. So you remember back to that case that I mentioned, the 2017 case, Andrew F. So there it says progress in relationship to reasonable expectations given the child. So all of this again depends, individually determined, right? So for a whole lot of kids, it's appropriate to say, are they making progress similar to that of their non-disabled peers? Because their disability affects them, but the supports we've got in place should help them to maintain that same progress that everybody else maintains. For other kids, that doesn't make sense, right? Depending on um, what the issue is and what the nature and severity of the child's disability is and what their IEP goals are and so forth. So what we're looking for is reasonable, meaningful progress in light of the child's circumstances. So meaningful, so growth. Can we check growth? And again, one of the things that the law is written so is to try to take away a presumption on our part, on the part of educators, that somebody can't, when with appropriate supports, they could, right? So don't default to assuming that the child can't make similar gains. Start with that as, kind of think of as, the defaults of your computer. What are the defaults? The defaults are that everybody's going to grow and we're going to help everybody grow. But sometimes defaults get altered because it no longer makes sense. I'm going to use a silly story maybe to explain kind of because this also goes along with this notion of inclusion. Those that know me know that I'm from a really large family. I have 7 brothers and sisters. I'm number 7. I'm one of the babies. I'm the youngest girl, brother a year younger. With that many kids, it won't surprise anybody that we didn't go on many vacations, but we had lots of family outings where they piled us all in the station wagon and off we'd go. Um, and one very memorable one when I was a little kid. So we went to Dickeyville to see the grotto. If you haven't been, go see the Dickeyville grotto. Anyway, my point is that when my family went there, my parents expected my older siblings to get a different benefit out of that experience than they expected us little kids to get out of the same experience. All of us were expected to benefit from the experience. All of us were expected to grow from the experience, but the expectations weren't exactly the same. That's really what we're talking about here. That's what Andrew F. is talking about. We have to have something meaningful growth and progress. But yes, that is going to depend in part on what the nature and severity of the child's disability is and what the unique circumstances of the child is and what makes sense given those unique circumstances. But our default should always be, can we help this child make similar gains as other kids? Oh, thank you, Danny.
Are there any other questions out there? These are great questions.
Yes, they are.
All right. Well, I know that Stephanie has shared a PDF of the slides the in the chat, and we've also shared the registration link to attend our next, I'll share it again, our next session. I'll just put it right here again.
Stephanie, this is an embarrassing thing to admit, but when you made the PDF, did you use the version I sent you last night before I caught my 2 typos?
Uh, I guess I don't know. We'll have to ask Stephanie about that. It's okay not to be perfect, Julie. You are pretty darn amazing, though.
Thank you, but they're pretty bad. There were stupid typos. I don't like seeing stupid typos.
Julie, I did, but I can fix that if you send me, and I'll just up replace the link that was shared. So I'll replace the PDF. So the link will still work. We'll just update it with the latest and greatest.
Thank you.
You're
Mhm.
just showing us what it looks like to be human. Really, it's okay.
Well,
Um,
that's
yeah.
obvious all the time.
Well, you're pretty amazing. Today was really awesome. We would really appreciate it for all of you attending if you would share your feedback with us. There's a QR code and there is Go Whiskey to You link. As Stephanie mentioned in the introduction, we've tried these on Saturday mornings, but we also want to hear from you what time of day and what day of the week is best. So, would it be weekend mornings? Is it just after school? Would it be lunch hours? We want to hear from you. So, we also want to hear what topics you're interested in learning about. There are lots of ideas. We have some amazing uh, you know, professors, assistant professors, associate professors at UW-Madison. There are also a lot of amazing community members that, we can bring in and, for collaborations as well. So please tell us what you're interested in learning about so we can honor your wishes and provide you what you're looking for. Thank you for being here this Saturday morning. Um, we hope to see you in our future place exchange webinars and other place opportunities. Remember that this will be available on the Place YouTube channel. We will not be posting the Q&A portion. That's only for people who attend live. So please share this with the people with whom you work. Definitely is beneficial for people in schools, clinical settings, families, just kind of an overview of what special ed law looks like. So thank you for being here. Stephanie, did I miss anything?
No, I think we're good. Thanks everyone so much.
Yeah, enjoy the rest of your weekend. Thank you, Julie. This was really super helpful. And thank you, Suzanne. We really appreciate all the time that you've dedicated to this webinar series. Thank you, everyone. Have a wonderful rest of your weekend. Take care.